Hello, good afternoon everyone. Thank you so much for joining us today. This is the next webinar in the One Chancery Lane weekly webinar series, and today, as you can see, we'll be tackling fraud, fundamental dishonesty, and talking about disingenuous personal injury claims. For those of you who don't know me, my name is Dominique Smith and I'm one of the more junior members of Chambers. I spend quite a bit of my time making fundamental dishonesty applications and dealing with fraudulent personal injury claims. I'm joined today by Simon Trigger, who is a more senior member of Chambers, who has extensive experience in dealing with these claims and also sits, as some of you have already heard, as a Deputy District Judge. So we are going to be discussing the relevant case law and some recent interesting decisions, what to look out for when you're dealing with or handling one of these claims. We'll also look at remote hearings and how fundamental dishonesty can be raised and if it's appropriate to do so in a remote hearing. We'll then look at whiplash reforms and have a question and answer session. But before we get to the meat of it, just to let you know, of course, you've already seen there are buttons on your screen. It will either be at the top or the bottom, depending on your browser. So if you have any questions as we go through, just tap the question and answer button and enter your question there. And Simon or I will try and answer those for you as we go along. Please don't use the raise hand button, only because we won't know what you're raising your hand for unless you type it out. So just type that out for us if you have anything that you want to say. If you want to generally just chat, as some of us have already been doing before this webinar, just use the chat box and we can have a chat with you there. So starting off then with the case law, there are a number of key cases in this area that are of seminal importance, and you should have all of these in mind when dealing with any claim where there is suspected fraud or indeed fundamental dishonesty. I'm going to try and give you a whistle-stop tour because I'm conscious we don't have much time today. Whenever one considers that there is a claim that may be fraudulent or fundamentally dishonest, you have to first look at what dishonesty actually means and whether the definition has been met. And one of the most important cases in that respect is that of Ivy and Genting Casinos, which is a Supreme Court decision in 2017. And it essentially concerned a claimant who was using edge sorting in a casino to improve his chances of winning. And he did win £7.7 million, but it was alleged that he had essentially cheated and therefore been dishonest. And Lord Hughes, in giving the lead judgment, set out the test for dishonesty, which you can see on the slides in front of you. And essentially, it is a two-part test. There is the first subjective limb of the test, where the court has to ascertain the actual state of an individual's knowledge or belief as to the facts, and it's not a requirement that the belief has to be reasonable. Secondly, there is an objective limb of the test. So once the individual's actual state of mind as to their knowledge or belief of the facts is established, the court has to then consider whether their conduct was honest or dishonest, and they do so by applying the standards of ordinary decent people. You must know that there is no requirement for the individual themselves to appreciate that what they have done is dishonest. So once you consider the test of dishonesty has been met, where do you go from there? Well, there was a question raised before the webinar about pleading fundamental dishonesty, and it was that essentially, what should one do if you look you think that you should plead fundamental dishonesty if you get an inkling early on that all is not right. And Howlett and Davis is a Court of Appeal decision which essentially says you don't need to plead fundamental dishonesty. So you may wish to do that, that's entirely within your gift, but you don't have to. What you do have to do, however, is give the claimant fair notice of a challenge to their honesty, for example, in cross-examination at trial. But that's something you have to give them notice of if you're going to be raising it. And some of you, well, I hope would have heard of the London Organising Committee of the Olympic and Paralympic Games and Hayden Sinfield decision. And this is one I often refer to as LOCOG for ease of reference. But it's one where essentially there was a volunteer at the 2020 Olympic Games who fractured his arm in an accident, and liability was thereafter admitted. But in terms of his schedule of loss when he was making a claim for damages, his claim for past and future gardening costs amounted to nearly £14,000. So the defendant was a bit suspicious of this and went and got evidence from the claimant's gardener, who said that the invoices provided in support of that head of loss were false, and that the claimant hadn't looked after his garden prior to the accident, and indeed after the accident the gardener's working hours didn't change at all. So what did the claimant do? The claimant decided then to serve an amended schedule where the gardening costs were significantly amended, and they were reduced to just over £1,600. The trial judge didn't, however, make a finding of fundamental dishonesty because he considered that the dishonesty didn't actually contaminate the whole of the claim and was essentially peripheral to it. So the defendant appealed, and the matter was then considered by Mr. Justice Julian Knowles. And he considered that the presentation of the dishonest gardening claim impacted upon the claim in a significant way, and that the claimant should have been found fundamentally dishonest pursuant to Section 57 of the Criminal Justice and Courts Act 2015. And as you may know, Section 57 can be utilised when the claimant is entitled to damages in respect of their claim, such as here where liability was admitted, but the court is satisfied that the claimant has been fundamentally dishonest in relation to the primary claim or a related claim. And Mr. Justice Julian Knowles, as you can see on the slides, stated that a claimant should be found fundamentally dishonest if the defendant proves on a balance of probabilities that the claimant has acted dishonestly in relation to the primary claim and or a related claim, and that he has thus substantially affected the presentation of his case. So you need to consider, has the dishonesty that you think is present actually substantially affected the presentation of the claimant's case, such that the claimant should be found fundamentally dishonest. Next, we have Melody in Cambridge, and whilst this is a motor fraud case, which those of you dealing with motor fraud I hope have heard of, it does contain some very helpful comments within it. And it was an appeal case in front of Mr. Justice Martin Spencer, who's provided a number of judgments in this area. And in that case, the trial judge had not made a finding of fundamental dishonesty, even though, for example, the claimant had clearly lied to his expert about how many previous accidents he had been involved with. So he had suggested to his expert it had only been one previous road traffic accident, but it actually transpired in the evidence it was perhaps 5 or 6, and in cross-examination he said it may have even been 7. And he'd maintained that lie in his witness statement. So Mr. Justice Martin Spencer on appeal essentially recognised the problem that we all know of fraudulent and exaggerated whiplash claims, and said that judges in the county court should approach these claims with a degree of caution, if not suspicion. And he set out some points that judges should consider. For example, has the claimant sought medical attention and returned in the event of non-recovery? And he considered that the court would expect a claimant to have done so. Did they seek appropriate treatment? And was their account hopelessly inconsistent, contradictory, or untrue? Now, if they didn't seek medical attention and didn't return in the event of non-recovery to their GP or to medical services of some kind, that in itself may point to the fact that the claim may not be genuine. And in addition, if their account is littered with inconsistencies and is contradictory or untrue, such as here with the number of road traffic accidents disclosed compared to how many there were, that again suggests that the claim is not genuine. On a side note, I had an appeal in a case earlier this year called Zabe and Cole, where the trial judge had said that the claimant's evidence was perforated with inconsistency, was exaggerated, and that the inconsistencies in his evidence didn't add up. But he refused to find him fundamentally dishonest because he said he didn't think he was deliberately dishonest. Of course, we know from Ivey and Genting that isn't actually the correct test, and it was overturned on appeal. And that decision really highlights that if a judge makes findings that a claimant's evidence is inconsistent or exaggerated, or in the case of Zabe and Cole, perforated with inconsistency, they have to give reasons as to why, despite all of that, they're prepared to accept their evidence in any event. And if they don't, that decision may be appealable. Mr. Justice Martin Spencer also gave a judgment on the same day as Melody in Richardson, McGran and Morris. And the relevance of this decision is that even though it was a motor fraud case, it does have applicability to other cases, in the sense that he emphasises the importance of claim notification forms, so CNFs, and their accompanying statement of truth. Because all too often we know that some claimants will list, for example, that they've injured in a CNF their left foot, their left arm and their head, but then they'll go on to tell their medical expert that actually they injured their right leg, their neck and their shoulder. And then you'll notice what they often say in their witness statement is, I agree with the contents of my medical report. But that's wholly inconsistent to what's been said in the claim notification form and entirely contradicts the statement of truth. So that's something that you do need to look at. And if you have inconsistencies in the CNF compared to other documentation, then the decision of Richardson McGran is particularly helpful, because it emphasises that actually more care should be essentially taken with these, and the inconsistencies in there, because they're signed with a statement of truth, can carry some weight. In Pegg and Webb, this is another recent decision of Mr. Justice Martin Spencer. He seems to be churning them out in this area. It was particularly helpful. It's a motor fraud case as well, but stated in that decision that if a claimant seeks no medical attention after an accident and solely undergoes physiotherapy arranged by their solicitors, this should immediately raise at least a suspicion in the mind of the judge. And sometimes, particularly in motor fraud claims, that's something that we see, that a claimant does nothing and just waits to have physiotherapy organised by their solicitors. So that's particularly helpful in a motor fraud context. Finally, I'll take you to another recent decision in this area, which is that of Garraway and Holland and Barrett. Now, it is a county court decision from earlier this year, but it was a very interesting one, in that matter came before His Honour Judge Simkis, and it concerned a lady who had struck her head on a metal shutter in the doorway of a shop, and that had been lowered just prior to the shop closing. And according to the judgment, she appeared to have problems when she could see that questions in cross-examination were leading her to difficulties in her case. There were considerable discrepancies between what she had said her injuries were and what her medical experts' views were of them. For example, she had said that she was knocked out and suffered some post-concussion syndrome, but her medical records said the opposite and quite explicitly stated that she wasn't KO'd. So what happened was the judge considered all of this and considered that the natural fact she'd exaggerated her symptoms and misled her expert, and consequently she was found to be fundamentally dishonest. And you can see there from the quote that His Honour Judge Simkis said, she may not have recognised that she was being dishonest because she's become obsessed with this case and with attributing her current medical condition to the accident. There is a considerable psychiatric element to this. Nevertheless, what she has done was objectively dishonest. So you see he's applying the decision in Ivy and Genting. And in doing so, she has misled the experts. Nothing could be more fundamental in a personal injury claim of this nature than to give the experts a false impression of her condition. So again, highlighting how important it is for claimants essentially to consistently report their injuries and not to exaggerate or fabricate them. So I thought it would be helpful to spend some time looking and talking about what things we should be looking out for with these types of claims. Firstly, I always look at the date of the CNF and compare that to the date that the claimant sought medical attention. It's actually quite a helpful point that I don't think that is picked up upon enough, but you'll often see a claimant in these cases who has gone to a solicitor, say on the day of the accident or the day after, and we know that because of the date of the CNF, and they do so before seeking any medical attention. And if someone was that ill or that injured, you would expect them to see their doctor first rather than to instruct solicitors. In my view, it screams of being wholly suspicious. As to injury inconsistencies, that's something, of course, I'm sure you all know about, is a key part in dealing with any claim that may not be honest. And it's something that we often win these applications for fundamental dishonesty on. You have to comb through the CNF, the medical report, the witness statement, any GP and physiotherapy records to see if injuries have changed over time. And there can sometimes be significant changes in their injuries. Sometimes it may be that a claimant says that they had neck and upper back pain, and then in another entry it says neck and upper back and shoulder pain, which there's not a massive discrepancy between, because essentially the upper back and the shoulders are not too far apart, and the claimant could have been referring to one and the same thing. But what we're really looking for here is the injury change from one side of the body to another. For example, are injuries mentioned in the CNF that were never mentioned to the medical expert, but then have reared their head in the witness statement? So that's the sort of thing you want to look for. But what you can do is, of course, when filing a defence, you can say the defendant notes that in the medical report the claimant reported these symptoms, however his CNF says the opposite, or the CNF says the claimant had 1 day off work, and in fact his medical report said he had 2 weeks. So I often in defences highlight all of the inconsistencies on the evidence I have thus far, which can be quite a helpful tactic when dealing with these claims. As to medical records, I think they're a bit of a goldmine, if I'm honest. I comb through them, and I suggest you do thoroughly to see if there are any other conditions of relevance or injuries in the areas affected, or indeed in terms of motor fraud claims, if there are any other road traffic accidents. You'd be amazed, of course, I'm sure many of you have seen them before, but sometimes the sheer depth of claimants saying, I've only ever been involved in 1 accident before, or I've only got this symptom, I've never had a back injury, and then their records say quite the opposite. But you can also tell if they've brought claims before. So you often see in the medical records entries that say so-and-so solicitors requested their records. So there's often an accompanying letter when you get those records that says why the solicitor wants them, and indeed giving the claimant's authority for their records. I've had cases before where I've spotted this, and I got out of one witness, for example, where I've noticed a couple of entries that they'd had 3 or 4 previous personal injury claims and effectively had received compensation of some £13,000. And I suggested to them that actually this was a source of financial gain for them in fabricating injuries, which the judge accepted. So that's something to bear in mind. Again, injuries that overlap with prognosis are also particularly helpful, because if they haven't been disclosed, they can indicate that the medical report prognosis cannot actually be relied upon. In terms of accident circumstances, you may see in a holiday sickness case, for example, someone saying they were so sick that they were confined to bed, and you have evidence to suggest that actually they went on an excursion during the period of illness. Or someone may say in a road traffic claim that they were hit in a stationary vehicle and they weren't moved in their seat, and then later they may say in their witness statement they were thrown about. And the key essentially to defending these cases is really in the detail. Of course, you can get social media evidence and the like as well. That's always helpful in these claims, and it's often ordered anyway, particularly in holiday sickness cases, but metadata is so helpful. I had a case not too long ago which was a travel case actually, where a lady had said that she suffered terrible food poisoning, and she said that during the course of the holiday she was confined to bed. And actually we got her social media evidence, and in every photo where she was supposedly ill, she had a glass of alcohol in her hand. So when I asked her about it, she said that she was just posing for the camera, which, as you can expect, did not go down particularly well. So social media evidence is also very helpful in these claims. I've already mentioned about flagging inconsistencies in your defence, but you may want to obtain surveillance evidence, for example. The only issue you have to bear in mind with surveillance evidence is if you obtain it extremely late in the day, there's always a risk that you won't be able to rely upon that in court. So it's something that you can bear in mind. But in the Holloway and the Garraway, and Holland and Barrett case, that's something that was successfully deployed, and it showed that actually the claimant, when she said she wasn't able to stand or walk for longer than 10 minutes, quite clearly was fine. So it can be extremely helpful. You may also want to offer the claimant to discontinue, and that's something you may be able to flag up all the inconsistencies and say, look, this doesn't appear to be a genuine claim, and put them on notice that you intend to make an application for fundamental dishonesty at trial. And what you have to bear in mind is that you can actually make such an application post-discontinuance. And it's something that may be a useful tool if, for example, you have warned them of the possibility of discontinuing and offered them to discontinue some months before the trial, because you've noted there are just so many inconsistencies and contradictions and untruths that this can't be a genuine claim. And say the claimant, for example, discontinues the day before trial, you can make such an application for fundamental dishonesty post-discontinuance, or indeed to strike out the claim. So there's a very helpful case in this area, which I've listed on the slides, which is called Zurich Insurance and Romain, which is a 2019 decision. And it stresses essentially, although it's a case that really deals with contempt proceedings, it stresses that one has to consider the timing of the discontinuance. And the judge said, had they essentially discontinued when they realised that the game is up, and contrast that to a claimant who's carried on nonetheless to trial, even though their claim may not be particularly a great one. So it's a very helpful decision when you're considering whether to make such an application after someone has discontinued, particularly if you've noticed all the inconsistencies some time before and you've made offers to discontinue and the claimant hasn't done anything until the day before trial. Alternatively, and we had a question come in about this before the webinar, you may wish to consider enforcement proceedings, for example, through the High Court, if you have had a judgment where a claimant has been found fundamentally dishonest and you want to pursue that further and ensure that you get your money. Alternatively, you can consider contempt proceedings, but that's something I think that should be proceeded effectively with caution, because contempt proceedings are very expensive, and just because you have a finding of fundamental dishonesty does not mean that you will automatically get a contempt finding. So you have to look at the evidence that you have and really consider whether this is something that in the circumstances is worth pursuing in terms of contempt. But that is of course an option to you when trying to tackle these claims and to warn others not to do the same. So I think now is the point where I pass on to Simon to talk briefly about remote hearings. I seem to have caught you by surprise, Simon.
I'm Dom, as you know, that I'm technologically incompetent, and despite that, I've been trying to answer the questions as they come in. So I think I probably need a formal apology for all my typos as well. Let me just finish the answer that I was typing. So Dom, entertain the crowds for 1 second, and then I will be with you.
Well, I'm just wondering if anyone spotted what's in your background. I said,
let's move on from that. Let's move on. I'll send that to Julie. I hope that helps. I'll just send that to you to deal with. Fine. Dom, thank you for that. I have been dealing with the questions as they come in, Dom, so you'll probably get all the nonsense, as in it's nonsense answers that I've given coming into you now. So I'll leave you to trouble yourself with those. I think I'm going to turn, for the purposes of this bit of the talk, into Chris Whitty, because as I say, I'm not technologically the most advanced, and Dom is in charge of the slides. So when I say every so often, next slide please, that's just so that Dom can move this along. I'm going to be talking on, quite specifically, the Whiplash reforms, as they've been called. It touches, of course, upon fundamental dishonesty. It probably is one of the reasons why we are having so many cases of fundamental dishonesty, is because how they arise in the Whiplash arena. Not to undermine my talk, of course, but the Whiplash reforms were, as I think we all know, due to come in April of 2020. Because the government was busy doing other things and or, depending on your view on these things, slightly incompetent, the government put April back to August. And again, as some of us probably know, there's been a few other things going on between April and August of 2020. And so the whole thing has been put back till April 2021. Sitting here now, as I understand it, the intention is still that in April 2021, this package of reforms will come in. But whether COVID and or Brexit and or something else hijacks all of this remains to be seen. So it may well be that what I'm about to talk about becomes entirely irrelevant and is not brought into effect. I think that is unlikely. I think something is coming, whether it takes precisely the format that we have at the moment, or whether it is amended in light of some of the commentary that is coming out, remains to be seen. Some of what I'm going to say will be well known to people listening. Some of it will not know anything about this. So I think it's probably helpful just to start back in the beginning. I'm going to also apologise at the outset that this talk may well seem a little bit jaded, a little bit cynical from time to time. that is because I am jaded and cynical, and they're my own views rather than anyone else's. The background, of course, to this is for those of you who are long enough in the tooth, way back when we used to have personal injury claims that were actually funded, and were funded, it may even be amazing to understand, by legal aid and matters such as that. We need to pick it up, of course, at the Jackson reforms. Before the Jackson reforms, everyone was proceeding on conditional fee agreements for whiplash injuries, which again, for those who are too young to remember, effectively meant that in a successful claim, the claimant could claim not only their full fat costs, there was no fixed costs in those days, apart from slightly weirdly counsel at the trial itself, they were entitled to claim your full fat costs together with up to 100% uplift. So you could double your money on the successful cases. In addition to that, to cover you for the risk of losing and having to pay the defendant's costs, you were also entitled to take out an insurance premium. And those were becoming quite significant, and that was all if you were successful, recoverable from the defendant. The defendant insurance lobby, and others, but predominantly defendant insurance lobby, were very unhappy with this because claimant lawyers, being a canny breed, realised that the way to make this very profitable was to ensure that you always won, and then you always got 100% uplifts. You never took the real risk of losing cases, and so defendants were essentially paying double costs for all cases. As I say, this is a cynical view, but a broadly accurate one. As a result of that, we got the Jackson reforms, and the Jackson reforms is, in simple terms, where we are now. Again, very familiar to most of you now. The Jackson reforms were part of a package, which in simple terms, which is what we have now, runs as follows. There is a pre-action protocol, which of course you are supposed to follow for every low value, and of course almost all whiplash cases are at the lower end of value. You're supposed to follow the protocol. In an ideal world where a defendant responds in time and admits fault, there is a self-contained system which will allow you either to agree damages and settle the whole case, or if the only thing outstanding is how much the physiotherapy should be or the general damages, to have a so-called stage 3 hearing. As part of that, we had fixed costs brought in, which again, as you will know, limits the costs that the claimant lawyers are entitled to recover where they're successful. CFAs, and at least CFAs inter parte, so what the defendant has to pay, were abolished. As you will, many of you will know, you can still claim something from the claimant's own damages. They were abolished, as were in effect after the event insurance policies, because of course, part of the package was QWOCs, qualified one-way cost shifting. The effect of that was that the defendant who was successful did not get their costs back, and so there was no real risk to the claimant, so they didn't need an insurance premium. That was the idea. I think the thinking behind it all was that defendants who would have to spend, let's say, £4,000 defending a case, and who, even if they were successful, would not get their £4,000 back, I think the concept was, well, that will mean that defendants, rather than just throwing £4,000 at their own lawyers, are more likely to spend it paying off the claimant. So the effect being there'll be less litigation. Just showing the law of unintended consequences, almost the exact opposite to that has happened, because defendant insurers have suddenly realised, well, actually, our liability is limited in that we know the maximum fixed costs we're in line for. If we can ensure that we don't pay our own lawyers too much, we can cap how much we pay per case. Actually, it's worth a go. And so, in fact, more cases are being fought. That hasn't been influenced by any great extent by Broadhurst and Tam. Again, that's a case in which the Court of Appeal effectively said, if a claimant has a Part 36 offer that they do better than, they effectively come out of fixed costs and go back to old-fashioned full fat costs. That, I think, was trying to really encourage defendants to settle as an outcome, and that has not really been successful, depending on how you look at it, either because claimants don't use the system very well, or because defendants are reacting and getting rid of cases where they are at risk. But in any event, we end up with more litigation, not less. But the relevance of all of this for the current proposals is that takes us to CPR 4416. That, as most of you will know, is an exception to QWOCs. QWOCs is the qualified one-way cost shifting, which means a successful defendant doesn't recover their costs. unless they can get themselves within either 4416 or 4415. 4415 is about cases being struck out, and so I won't say any more about it at the moment. 4416 is if the claim is fundamentally dishonest. That was deliberately chosen as a new terminology at the time, that its remit was going to be explored in due course. And that is the background to why fundamental dishonesty is now such a hot potato, because it provides the obvious, and many would say only, way in which a defendant is able to recover costs against the claimant. So it has to an extent incentivized defendants to raise an argument, because if they're successful in it, there is at least the possibility of recovering some costs. That is the background. Now, what has happened since then is, notwithstanding that those reforms have not been in for very long, notwithstanding that the effect of them probably hasn't played out fully yet, the defendant insurers are now concerned that there are even more cases, and more of them are being labelled as fundamentally dishonest. Well, how has that happened? I've indicated the first reason, which is that defendants are more keen to plead it because it's the only way they can recover costs. But, and apologies to all claimant lawyers on this webinar, the other effect is, because fixed costs are set so low, to make it a commercial exercise, claimant lawyers tend to spend less time looking at their cases and have less qualified fee earners. It's a generalisation, but there's some truth behind it. Because of that, the kind of inconsistencies that Dom has been identifying, inconsistencies between medical reports and witness statements, between GP records and medical reports, which back in the old days would never have come to light, because the claimant lawyer would have taken time to go through it all, point out the problems, and either clarify it or drop the case. Those come to light for the very first time at trial, because no one spent any time looking at the case. And so you have what might at first blush seem to be a fundamentally dishonest case. Often it's because there's just pure inconsistencies that have arisen because people haven't been careful enough in the case preparation. So those two processes have meant that there is a much higher incidence of fundamental dishonesty, at the very least, being raised. What that now means is the defendant insurers are able to say, well, hang on, there's so much fundamental dishonesty out there, we need to do something about all of this. Quite a vicious or virtuous, depending on your starting points, circle that's taking place. So why are the changes? I just wanted to put a couple of quotes in, because I think they're quite interesting as to what is going on here. The two quotes, I've put them in there. I'll go with Chris Grayling first, many people's favourite politician. Dom, can I go back to the first slide? Thank you very much. I did want to feel like Chris Whitty. Can I just take you to his quote? This is what Chris Grayling said when the proposed changes were coming in. The government is determined to do more to reduce insurance premiums further to help with the cost of living. A worthy aim, one might think. Fraudulent, exaggerated, and I put the underlining, unnecessary insurance claims continue to place a significant financial burden on each and every motorist. Quite an interesting discussion can be had as to what constitutes an unnecessary insurance claim, particularly if it's one that is not a fraudulent or exaggerated one. But that perhaps shows what is going on. And you'll see from the top quote, very similar thought process. The proposals are aimed squarely at tackling the compensation culture which has grown up around whiplash claims in recent years. That culture is fueled by a substantial industry of sustained nuisance cold calls and targeted advertising, which encourages motorists to make claims when, and let's look carefully at the wording again, little or no injury has been suffered. Again, one might think there's a perfectly legitimate distinction between bringing a claim when you have a little injury and bringing a claim when you have no injury, but the two are just nicely allied together. So that's the background. That's why the government are bringing this in. What are the changes? Dominic, next slide. There are a few things that you need to be aware of, and we'll look at in more detail. I'll give you the overarching view first. The starting point is something called the Civil Liability Act of 2018. That effectively tries to define injuries that will fall within this new scheme. If you fall within the Civil Liability Act, your compensation will be fixed by regulations rather than the Judicial College guidelines as we traditionally understood them. There are no formal regulations yet. There were some draft ones that were published, but whether they change by the time it actually comes into effect will have to be seen. I've put the tariff later in the talk as to what the proposals are. As I say, they're only proposals at the moment. As part of that, to really drive home the point, the small claims track limit for road traffic accident cases is going to increase for general damages from £1,000 as it is at the moment to £5,000. In other areas, it will increase to £3,000. So it is, road traffic cases are being treated very deliberately differently. There will be, because of course, the effect of putting all of these cases onto the small claims track will mean that there are in reality no or de minimis legal costs recoverable, even in successful cases. It is anticipated, and it is designed, in fact, to drive claimant lawyers out of this kind of work. So, expecting a deluge of litigants in person, there is now an online portal that everyone is going to be driven towards, which is operated by the MIB. It is supposed to be effectively a process that you start at one end and are churned out at the other. You're churned out either with a successful conclusion to your case, or you're churned out with a court hearing. That's effectively it. There should also be a pre-action protocol which will dictate how one proceeds on the online portal, but you'll sense a common theme here, that is not yet published. Importantly, perhaps pedestrians, motorcyclists and cyclists are excluded. Children, I put a question mark. I'll come back to why that is in a moment. And another invention is that you will not be allowed to settle cases, Section 6 of the Act, unless and until you have a medical report, which you have to obtain through the online portal. So that's the overview. Let's have a look at the detail a little bit more. Civil Liability Act. The most important thing really is to ascertain whether you fall within this or not. And so here is where the definition effectively of whiplash lifted from the Civil Liability Acts. So Section 1 is relatively straightforward. You will fall within the scheme if you have an injury of soft tissue in the neck, back or shoulder that it is of a description falling within subsection 2, but not including an injury accepted by subsection 3. So subsection 2, which is the one below, which is it's an injury of the soft tissue, neck, back or shoulder that falls within this definition. It's an injury if it's a sprain, strain, tear or rupture or lesser damage of a muscle, tendon or ligament in the neck, back or shoulder. So far, so straightforward. Or an injury of soft tissue associated with a muscle, tendon or ligament in the neck, back or shoulder. I'll come back to this, but there is no definition of what is meant by the word associated in that subsection. And that may well be an area that is going to be explored, particularly when we now look at subsection 3. So subsection 3 is injuries that are excluded. So they are an accepted, so don't fall within the definition. An injury is accepted by this subsection if it is an injury of soft tissue which is part of or connected to another injury, and the other injury is not an injury or soft tissue, neck, back or shoulder of a description falling within subsection 2. Got it? All clear? Now, what's interesting about that is that there is also no description or definition of when an injury is connected or part of another injury. So that is going to be an area, I suspect, of quite significant litigation. I just throw out a couple of examples for people to think about. If you have, for example, a neck injury, and at the same time as the neck injury, which is caused whiplash, you being hyperextension, hyperinflection, you manage to headbutt the steering wheel as part of this and suffer brain trauma. Is that an injury that is associated with a muscle, tendon or ligament in the neck, back or shoulder? Is it an injury that is connected or part of the injury to the soft tissue, to the neck, back or shoulder? Or is it not? If it's an arm injury together with a shoulder injury, where does that fall within this? I think that's going to be explored in due course. You can see why they've had difficulties, because the intention of all of this is clearly to keep soft tissue neck injuries within the framework, but other injuries outside of it. But whether they've achieved that through their definition, I think will remain to be explored in due course. The whiplash injury regulations, which as I say are draft, make it clear that, as I've put there, one or more minor psychological injuries suffered at the same time fall within the tariff. Perhaps of note are two things. First of all, you get the same sum, which is a bit odd, but secondly, the word minor is not defined. Is a minor injury defined by its diagnosis? Is it defined by the prognosis, by the duration? So, for example, is PTSD that lasts for 2 days a minor psychological injury? Is travel anxiety that lasts for 3 years a minor psychological injury? The answer is, I don't know. No one does. It's going to have to be tested. You can see what they were trying to achieve. They were trying to mop up, as part of the definition of whiplash, minor travel anxiety that we often see diagnosed by the GP, or some sort of slight minor phobia, by which I mean, you know, trying to avoid roundabouts for a couple of weeks. That's what they're trying to catch, but they haven't, in my judgment, haven't achieved that very well by this definition. And so again, that will need to be explored through litigation in due course. There is an exceptional circumstance where, which is undefined. The court may have the power to add a 20% increase to the figures. So, Tom, next slide. What are the figures? Well, anyone who's a personal injury lawyer, buckle up your seatbelts, because there they are. So if you suffer, let's take the most straightforward example, a whiplash injury, which affects your neck, takes you off work for a couple of weeks, and we're talking a proper injury here, not anything that is suspicious. You stoically get on with your life, and after about 3 months, you're fine. If you had suffered that injury walking down the highway, tripped over that horrendous defect that the Highway Authority had left there, you would probably get a sum somewhere in the region of about £2,300, taking the bottom bracket of the neck injury for the JC guidelines. If you suffer exactly the same injury, but in a car, you'll get £235. Is that fair? Is there any logical distinction there for the same injury getting different amounts? Answers on a postcard. That is what you're going to get. And you can see the exceptional circumstances. So you've proven there's exceptional circumstances in your case. However that's defined, you're the rare exception. You get 20% more. You know, Nando's are on you, is all I can say. It's not going to make much of a difference to life. So the awards are derisory. The only justification that is marshalled is that there are too many fraudulent, exaggerated, and I quote, unnecessary whiplash cases out there. Whether that is a fair outcome for claimants is probably something that we could have quite an interesting chat over a large glass or something for. As I say, those are the proposed tariffs. I think those tariffs, that's been in existence for quite some time. I think it is likely that they are going to be in that ballpark. You can see now as well quite how cynical the changes are. The reason why the small claims track for road traffic has gone up to 5,000 rather than the 3,000 for every other type of personal injury case is to make double sure, to doubling down that there is no way this is going to get onto the fast track. So you are stuck on the small claims, because had it been 3,000, of course, if you had your whiplash of 15 to 18 months, you could legitimately, at the point of issue, say, well, there's a chance we might get over £3,000. So actually it's legitimate to put this on the fast track. This is a doubling down of you are not getting it on the fast track. Again, you may, as I do, think that's quite cynical. I think it probably is. Next slide, please, Dom. I've already mentioned there the increase of the small claims track to 5,000. That's the portal, the officialinjuryclaim.org.uk. I do find it mildly amusing that you might think that's a very odd website name for what this is. Bearing in mind the concept is that Joe Bloggs, who has his road traffic accident, can go home and think, oof, I've got my whiplash injury, I'm going to do this myself and make a claim. You might not think it's immediately obvious he would land at www.officialinjuryclaim.org.uk. And the amusing element is that's because everything that you might have wanted to get, such as personal injury claims, such as whiplash injury claims, such as whiplash portal, had all been snapped up by various accident management companies and claimant lawyers. So they weren't available. So they had to go with that. I've already mentioned the pre-medical report. You can't settle without them, which gives rise to an issue which I'll come on to in a moment, but it does mean defendants will have to wait for a medical report before they can make any settlement, or indeed, in fact, offers to settle, which can be accepted. Next slide, please, Dom, conscious of time. Now, I've dealt with this in passing, and I've just put it there again because you've all now had 10 minutes to think about the definition. It comes back to really how this is going to be operated in practice. When is it going to be said that an injury is part of or connected to another injury, such that it is no longer as defined a whiplash injury, or when is it going to be simply associated, in which case it will be a whiplash injury? So I put there a couple of examples there, arm injuries, foot injuries. Now, here comes the very personal, very cynical element. Anyone who's involved in whiplash cases for the last 12, 18 months may have noticed a very odd trend. And the very odd trend that certainly I have noticed in my cases I've dealt with, usually on behalf of defendants, but not solely, is that claimants suddenly have started to injure other bits of themselves. Having done this job for about 15 to 20 years now, I don't think I'd ever seen a claimant whose foot had slipped off the pedals and twisted their ankle. And yet I've seen about 5 in the last 12 months. I don't think I'd ever seen a claimant who'd been thrown with such force sideways that had actually head-butted the window and had a minor injury. How has this happened over the last 12 months or so? Well, the pure cynics amongst us might think that some very clever claimant lawyers, or possibly claimant doctor lawyers, have realised that this definition may well mean that if you've injured your foot, which is difficult to see, is part of or connected to, is an injury that's associated, with a muscle tendon in the ligament, neck, back or shoulder, it might be thought that that takes you outside of this whole regime. Certainly that's going to be an argument that is going to be run and tested. And if that's right, it would look very, very suspicious if suddenly claimants on the 2nd of April were suddenly presenting claims where they injured their ankles. But of course, if those have already been circulated in advance, it might be thought, if one was cynical, that that's is a good way to test where this definition lies. The alternative, less cynical and probably equally valid argument is that actually because of this, people are asking the claimants the right questions. And in fact, lots of people have injured their ankles in these accidents. It's just that the doctors never asked them because that's not what they focused on. They focused on the neck, the shoulder and back. So there is a cynical explanation, there is a perfectly straightforward explanation, but it's noteworthy that I think the sides are gearing up for this to be a battle as to what falls within it. Next slide, please, Dom. The other element to that is how is this going to be treated in practice? So let's take my foot example. If the foot injury does count as an unconnected injury, but you also suffer a neck injury, is the approach going to be that those two injuries take it completely outside of the Civil Liability Act, so that you're back into old-fashioned Judicial College guidelines, or is it that you get 2 different awards, one for the whiplash, which is under the tariff, and one for the other injury? And of course, if it's that, you then may well end up with 2 different costs decisions as well. Again, there isn't an answer to this. I raise the problems to encourage people who are cleverer than I to see arguments that are quite sensible arguments to raise as to how this should be applied in practice. You will see that the section 3.8 there, which I've quoted, might suggest, which you'll see that nothing in this section prevents a court in a case where a person suffers an injury or injuries in addition to an injury or injuries to which the regulations apply, awarding an amount of damages PSLA that reflects the combined effect of the person's injuries. But then it says, subject to the limits imposed by regulations under this section. Well, does that mean that you're stuck with the tariff award? We will see in practice. So it's difficult to know how that's going to play out, but there's clearly an argument to be had there, which is going to probably define how widespread this whole new system is in practice. Next slide, please, John. A couple of technical points, but critical points. The first is this, and it's a pure piece of penny pinching. The online portal used to have built into it ADR. and there was going to be an independent panel. In fact, anyone who, any DDJs on the line may know that there was an idea floating around that people who were both in practice and DDJs would all be hawked out as arbitrators for this process. And there were various companies and businesses thinking that was a jolly good idea. The government, having seen how much that might cost, has pulled the plug on it to save money. So there's now no ADR, which you may have a view about, but I suspect it's one of those, be careful what you wish for, because if you're now a claimant, who, bear in mind, is supposed to be acting in person, you get your medical report and it tells you you've got X amount of injury, and the defendant, who you clearly are unlikely to trust because they're the other side, tell you your injury is only worth £400, here's £400. The claimant's got two choices there. Choice number one, of course, is to say, oh, okay, thank you very much for telling me, I'll take my £400. Choice number two, however, is to say, no, I don't believe you. I'll take my chances in court, thank you very much. There's nothing to stop them. And indeed, as we know, Cox hasn't been abolished, so it's unlikely the defendant would get their costs back. Is it unreasonable for a claimant to reject the offer in those circumstances? It'd be difficult, as they're litigants in person. What may well happen, and Dominique Regan, who many of you will know of, fears this is what's going to happen, is there's going to be a deluge of litigants in person coming to court with cases that effectively shouldn't be there, precisely because they've had no opportunity for anyone to give the litigant in person an independent advice to say, yes, your case is only worth £400, please take the offer. And of course, then defendants are in a difficult position. What do? Do they turn up to these slightly pointless hearings and say, well, yeah, we offered him £400 because he gets £400 under the tariff? I don't know, but that's going to be the effect, or arguably an effect, of removal of ADR. The other catchy difficulty at the moment is digital disenfranchisement. Those of us who have the pleasure or displeasure, depending on your starting point, of living in London, tend to proceed on life, and no doubt those in the Lord Chancellor's Department, all living in Hampstead and Highgate and places like that, all have wonderful Wi-Fi and all have no doubt beautiful Apple computers. They tend to forget that most claimants don't, or certainly a significant percentage don't. And what are they supposed to do? How are they supposed to access this online portal? And it's not just a one-off, go to the library and sort it. They have to follow this process through. The government has said there will be a paper copy and version of all of this, but nothing has been produced thus far. A very technical point for claimant lawyers is fee remission has not been extended to the cost of the medical report. The medical report is, as is at the moment, £216 inclusive of VAT. The claimant cannot settle until they get a medical report. So unless and until fee remission is extended, you have the pure catch-22 situation of a claimant who does not have to pay an issue fee because they have fee remission, but they cannot settle their case because they cannot afford to pay for the medical report. There we go. Nothing being suggested that fee remission will be extended, because of course that will cost the government a lot of money. Next slide, please, Dom. I mentioned children. Children at the moment, and you'll see that, are supposed to be outside of the increase to the small claims track limits. That's what's been said, but the logic of it, and you'll see at the bottom, they're still subject to the Act, but the logic of why they're excluded is quite interesting. Mr. Buckland, who I think, this is always a good pub quiz question, I think he's still our Lord Chancellor. It does change quite frequently, but last time I checked he was. He said this when trying to justify why claimants and protected parties are out. He said the claimants will not be subject to the new small claims limit. They will also not be subject to the new pre-action protocol, which hasn't been published yet, and so will not have access to the online service. As such, they will not be able to source their own medical report via the online service, which is statutorily required to settle the claims. Therefore, until they can access the online service, the normal track for claims by children and protected parties, which includes a whiplash injury, will be in the fast track, and these claims will not be allocated to the small claims track. This means that, for now, these claimants will be able to instruct legal representatives who may obtain a medical report on their behalf, and their costs of legal representation will remain recoverable. I'm curious as to why, because if the injury falls within the Act, they fall within the tariff, they're going to get awarded £200. That's a small claims track valued case, even at a £1,000 limit. But that's not a very political thing for the government to say, because it would look pretty bad if claimants and protected parties were supposed to go off and sort themselves on the online system. So at the moment, they're supposed to be out of this. But it's very clear that they're going to be hauled into it at some stage in the future. Thank you, Dom. You can work out why that picture's there. Two things to leave you as a thought. Everything I have just said, and you will have your own views depending on your starting point as to whether this is a good idea, whether it's likely to work, how much chaos it's going to cause. All of that is to save, on the government's own estimate, each one of us £35 per year on your insurance premium. Is it worth it? You can discuss that. The other thing that I think is very important to bear in mind is that credit hire is not being touched on this. And anyone who has practical knowledge of these cases will know that in a lot of cases, the whiplash injury is in fact a bit of a sideshow. It is routine to have a credit hire case of thousands of pounds, tens of thousands of pounds, with a minor whiplash injury case as well. That case is not being fought because there is a whiplash injury case. That is being fought because there is a significant credit hire case. And everything in these whiplash reforms does not deal with that element. So it seems to me that in fact, many of these cases will still continue because the credit hire is the motivating factor behind them. That, I hope, is a bit of a whistle-stop run through of the proposal, so at least you know what is in theory coming. I have no idea whether questions have been asked by this. I'm also going to choose to believe that Dom has been responding to them as they arise. Let me have a
questions actually that we've had in. Obviously, if you have any more, feel free to pop them in the Q&A box. So a couple regarding the points that you've been making about the portal. Claire says, regarding the portal, what if you have a whiplash injury that does not recover as expected and develops in time into a chronic pain condition, which in turn causes a significant psychiatric injury to develop and the claimant is no longer able to work?
So the answer to that, I think it's a little bit like, I suspect anyway, how we are on the portal at the moment. It's not clear because the pre-action protocol that will dictate how you operate the portal and when you should use it hasn't been published yet. But I anticipate, and I think it must be right, that if a case develops, there will be a mechanism by which you come out of the portal or the online system and go into a normal case. So, for example, at the moment, one might have a claimant who comes to you and you think you're looking at a low-value whiplash case, so you put it onto the portal, and as we all know, you may well, as you start to develop, your client suddenly says to you, oh, what about these splitting headaches I'm getting every day now? It's really causing me trouble. And you start looking into it and you suddenly realise there's a brain injury type case there as well. Then if it gets big on you, then it will come out of the system. I'm pretty confident something very similar will be in place, and you would certainly not be criticised for not following the portal in those circumstances. Of course, if you've settled your case by then we're into a whole different territory of professional negligence, but that's a different issue.
We've had another question from Bernard who says, who decides what the value of the claim is and at what stage? Is this going to be an issue for litigants in person?
Good question. Next question. Absolutely right. I mean, Bernard, a very good point. How, and not least, how are they supposed to know that? I mean, you know, is a claimant who has their whiplash, I think the idea is the claimant has a whiplash is going to turn up at a solicitor or tell their insurance company, and one or other of those will say, really sorry, looks like a whiplash injury, you're on your own, Sonny Jim, off you go, here's a card showing you where the portal is. I think that's the concept behind it, but you're right. How does the claimant know that? I think that's why, in fairness, the claimant cannot settle the case until they have a medical report, because at least then there is a doctor who has cast their eye over the claimant. Your views on what medco doctors are like are probably all best kept to yourselves. But at least someone has looked at it and can say, oh, hang on a minute, this is a bit more serious, or, oh, this is the bog standard 6, 12, 9 months, whatever. I think that's the answer, but it's a good question.
We've had another which says someone's got a section, it's Lisa says she's got a section 57 case and the claimant has a private Instagram account. And what do we think about adding the claimant via a fake account in order to have their own relevant information?
Yeah, I'm going to let Dom answer that because I understand most of the words in that sentence, but not quite all of them. So I'm going to let Dom, who's far more younger and IT savvy than I am, answer it.
I mean, what we often do in these cases, and we all know this, is we have a look on social media beforehand, and see what's on someone's profile. Is it going too far adding them from a fake account. One, I think they might cotton onto it, but two, I think it's slightly risky. I don't know about you, Simon. I feel slightly uncomfortable about it.
I'm pretty confident, without giving you an answer you can sue me for, I'm pretty confident that there would be data protection principles engaged in relation to that. And there's a whole area of case law about illegally obtained evidence, and illegal constitutes in breach of various requirements. I anticipate that that's a bad idea to do that. So I would, and I mean, I'm afraid social media evidence always looked, insurers love it because they get the claimant with the shoulder injury and they have a lovely picture of him fly fishing. And the insurers salivate with joy and say, there you go, we've got him fly fishing, without ever doing the actual basics, which are, you've got to find out, when was the photograph taken? When was it uploaded? Who does it show? It's a one-off picture of him holding a fishing rod. Very rarely do you get the video of them actually fly fishing. You know, all of these things actually tend to undermine it. So I'm always a little bit suspicious as how far social media evidence takes you. It's clearly relevant. You clearly should obtain it where it's publicly accessible, but it's only a block in the argument against the claimant.
Yeah, I think also, as we've said before, that if you have metadata, that's incredibly helpful, because if it can indicate when a Facebook post was put up and things like that, or if you've got photos that have metadata that's from someone's camera. That's how I was able to deal with in a case where the claimant had been drinking alcohol on every single day after her alleged illness when she was apparently sick in bed. But that the metadata is really essential. But as Simon says, if you've just got some pictures, some are obviously going to be more helpful than others, depending on the type of claim. If someone's saying that they can't walk and things like that, and they're at Glastonbury, you know, that's going to help you, obviously. But if you have others, it may not help so much, depending on the circumstances of what they're saying is wrong with them.
I think the other thing to always bear in mind, and I think both sides forget this, is that the one person who knows whether they're lying is the claimant. And you know, and that's irrespective. That's in every case, even whatever the judge thinks. Ultimately, the one person who knows is the claimant. And so, going back to one of the questions which Dom dealt with earlier, which is when you should raise fundamental dishonesty. And Dom's obviously right. Howlett is the case, which says sort of you should give them notice. It can arise at trial, but actually, people often forget. If the claimant knows they're lying, then the more that you let the claimant know you're onto them, the more chance you've got of the claimant thinking, do you know what, I don't fancy this. So there is something, and you may not get your ritzy FD finding, which you can advertise in the, you know, the Insurance Times and show how musculature you are as a defendant, but you've scared off the claimant, and that ultimately is the name of the game here. So social media, in my view, fits in better in that picture, which is that if you've got the picture of them fly fishing, get it and produce it and say, excuse me, can we have an explanation, please? Now, of course, you'll get an explanation, but the claimant themselves, when their lawyer comes up and says, could you just explain to us why we've got you fly fishing on this day, is going to be thinking, oh gosh, I've been caught out. And that actually, which is what you should be doing, which is trying to discourage claims and win for your client, that is better to flush it in that way, even if you don't then get the metadata or the video of them fly fishing.
I know that we did have a message prior to the webinar, which I've just remembered a question about whether, from Mike Hagan, whether there should be potential cost consequences for defendants who raise fundamental dishonesty, which it's not borne out.
I think it's a very good question, and it's a common gripe, I think, putting it bluntly, from claimant lawyers, because at the moment there is a sense that it's a free hit for defendants, and to an extent it is. I think there's two answers to it, though, however. So if one bears in mind how fundamental dishonesty arises, and just take it in the two obvious ways. If it's section 57, so that you have, and of course you should be pleading section 57, which is that you're trying to strike out the whole claim because part or a substantial part of it is fundamentally dishonest, then that will be pleaded, and as a claimant, at the end of the case, you're perfectly entitled to say, we won on that argument. We won on the argument about fundamental dishonesty. I would like my costs of that. And that, depending on where your case is, if it's tiptoed into the multi-track, for example, one can seek the costs of that. If you're on the fast track, well, you may be in sort of exceptional circumstances. There may be arguments where you can try and claim cost for it. If, however, what is more commonly it arises, where the defendant at the end of the trial suddenly jumps up and says, I'd like to make an application for fundamental dishonesty, and we did at least tell them this in advance in the letter. It depends how the court deals with it. If the court just deals with it there and then on the hoof, then there's no self-contained unit of costs. But you might be able to say to the judge, well, that's a very serious allegation. We need to take some time to consider, because my client's entitled to consider it. And if you can get it as a freestanding argument, then of course the costs of that freestanding argument are a live issue. So there are ways to allow the claimant to put a defendant to their mettle, and to try and actually put some cost risk onto them. The reality, I'm afraid, is that most judges, in dealing with their judgment, deal with fundamental dishonesty at the same time, so that in fact you don't get the opportunity to do that, and it does make it very difficult. The other cliche, sorry to talk over Donald completely, but the other way of doing it is to go a little bit old-fashioned on it and say, well, this is such a serious allegation, this needs to go onto the multi-track, and there's no way my client can deal with this, because I want every single person in my fly fishing photograph to come to court to say what he was doing, and you'd be entitled to. So that's the other way, and if it turns into a multi-track, of course, then the cost consequences follow from that. But I'm not sure, Dom, if you agree or disagree or approach it differently.
It all sounds very sensible.
Sensible law, that's what we try to do.
I was going to say, unless anyone's got any other questions, I can't see any others that have come through. No, come through. He says, I recall an American claimant's lawyer saying that it's all very well showing photos or videos surreptitiously taken of the claimant's behaviour, but they do not show how the claimant was able to behave prior to the accident or the pain they're suffering from. So even now, normal behaviour now is limited for them. I mean, it's a fair point. It depends on the circumstances of your case and what the injuries are that are alleged.
And nothing's really changed, because back in the day with surveillance footage, it's the old chestnut argument, good days, bad days. That's what the claimant always said. Even when they were caught playing football, the argument, as I say, long before fundamental dishonesty, the argument would be, well, you got me on a good day, I'd absolutely dose myself up to the eyeballs with painkillers, and gosh, you should have seen me 10 minutes after the video finished. I was lying on the floor and angrily screaming. And it's true. And photographs, videos, social media, they're only pieces of evidence, each one of them. And the truth of all of these is, it actually depends upon the claimant. If the claimant has an explanation for it, and one that they are able to put forward with a straight face and some credibility, then it's not fraud. Whereas if they don't, then, well, hang on a minute, what's going on here?
Absolutely. I mean, I've had a number of cases where there have been lots of inconsistencies, but the claimant, when they give their evidence, it's just actually a bit useless, and they don't come across dishonest at all. But then you have other cases where obviously they come across really badly. So just because someone has all the kind of indicators that they may be lying doesn't mean you'll necessarily succeed in that application. It's largely down to how they come across.
It was interesting. We had a question earlier, Don, when you were giving your part of the presentation, from someone who sits as a DDJ, and they were just asking what the prospects on an appeal for either a finding of FD or not a finding of FD were. And I think it's quite an interesting area, because it does really turn, all of this turns on actually how the claimant came across. Because, I mean, the test for dishonesty is Ivey and Genting, which has a very technical test, which is all about whether it should have been objective, subjective, etc. But the reality is, all judges think they know dishonesty when they see it. And there's and the truth is, most people involved in litigation do. Because, as Dom rightly says, you will have a claimant who has been probably very badly served by the legal team that they've got. So they come up to court with massive inconsistencies, all sorts of problems all over the place, but they stare down the barrel of a judge and say, yeah, you're absolutely right, that's wrong. I once, when I was probably about Dom's stage, I had a absolutely juicy case in Southend. Claimant was all over the place. There were not mentioned previous accidents, inconsistencies in where the injury was between the witness statement and the GP record. And I was thinking, rubbing my hands in glee. And I got to court, and the claimant, who slightly depressingly was a very nice sort of middle-class seeming lady, she was a teacher as I remember it, in she goes in the witness box, and I hit her with the first inconsistency, which was, how do you explain that? And her answer was, gosh, yes, that does look bad, doesn't it? That's terrible. I don't know how that's happened. I'm really sorry for that. At which point you just think, she's going to win, because yes, it's all over the place, but she's not coming across as dishonest. Whereas had she gone, oh, I'll try and call a square a circle, the judge would know, hang on, this stinks. So, you can have as much fun and games pre-trial as you want. Actually, it just depends on how the claimant will come across.
And we've had a question from Kieran who says about what are our views on Part 35 responses and the medical expert accepting that there are discrepancies in the evidence to what was reported to them by the claimant. Are there good grounds of an FD finding? I mean, my view, Simon, is it depends on precisely what they're saying, because they may accept that there's some discrepancies in what's been said, but it depends on whether that's altered their conclusion and their prognosis, and whether you can successfully argue that actually they've misled their expert or attempted to, and the like. I don't know what your thoughts are.
I'm afraid, Kieran, you've tiptoed into one of my absolute pet bugbears I was hoping not to have to rant about. I'm going to rant about it now. Part 35 questions are misused badly by both sides in this type of area of litigation, in my view, and it sounds out at trial. So what tends to happen is the defendant, you tend to only obviously have an expert for the claimant in these lower value cases, and the defendant's questions tend to be pro forma. I understand why, because there's cost pressure, and so it's easier. But you get questions such as like, do you accept that if the claimant didn't tell you the truth, then that might call into question your report? It's a pointless question, because no judge now, even if the expert says, no, actually, I have some clairvoyant mechanism whereby I can see through what the claimant's telling me and I can tell you if they're lying. Even if they say that, the judge thinks, well, so what? Because I'm going to decide whether this person's lying. So questions like that are unhelpful. And also what's unhelpful is because of the pro forma nature, nobody actually gets to grips with the real issues. So where you've got a claimant who has 7 previous accidents and an ongoing history of neck pain and hasn't mentioned it, that's what you should be asking the expert. You should be saying to the expert, can I take you to this GP record? 1, is that what you were told? 2, does the fact you were told it cause into question the reliability of what the claimant's telling you? And again, as every good cross-examiner knows, it doesn't matter what the answer is, it's the question, because you sow the point with the question. And so even if the expert says, well, no, because actually it makes no difference that they've got a 40-year history of chronic neck pain and they never mentioned it, the judge will think, well, that's just nonsense. It's clearly highly relevant. So focus the questions better. If you get an expert saying, actually, what they've told me is entirely inconsistent with what I'm now being shown, you don't need to go any further. It may well be a solid basis for an FD finding. Again, the proof is in the pudding. What does the claimant say about it? Because often, and this is again the bit that's missed, people assume that what's put in the medical report arises from the questions they'd expect to be asked. The obvious and classic cliche is it says in the medical report, the claimant says he has no previous accident history. Okay? And you find out the claimant, in fact, 4 years ago had 3 road traffic accidents in which he claimed neck injury. And so you think, brilliant, go for him. And you say to them, why didn't you mention it? To which the answer given is, because I was asked how many accidents in the last 12 months or in the last 2 years. Well, at court, how on earth do you get behind that as an answer? You're stuck with it. Whereas if you'd used your Part 35 questions, knowing that there were these accidents 4 years earlier, so you say, did you ask him, or tell me, what precisely did you ask him about past medical history? What did you ask him about past accident history? And then look at these. Does that mean that what he told you is wrong? And then you've got him. There's nowhere for the claimant to go in those circumstances. So people, I think the answer to the question is yes, it could be a solid basis for a Section 57 or a fundamental dishonesty finding, but you've really got to put the evidential planks in place through well-targeted Part 35 questions. Sorry for the rant.
It's all right. And on that note, I'm conscious of the time, so we'll probably call it a day there. You've, of course, got mine and Simon's email addresses on the screen. And next week, we've got Henk and Richard Cherry.
You're welcome.
Possession post-COVID. So do tune in for that. But thank you all so much for attending. It's been great chatting to you. Obviously, we can't hear you, but it's been fun anyway. I don't know if anyone spotted what was in your background, but maybe not.
It's so ridiculous. I'm not even going to tell you. I'm just going to leave you all to think about it and give you a reason to study the video again in the future when it's sent to you.
Perfect. All right. Well, thank you all so much and take care. It's been a pleasure.